Get ready for the dictation. Start. In 2009, Corporate Power Limited set up a thermal power project in Jharkhand and for so doing availed of loan facilities from various lenders including the State Bank of India. The account of the corporate debtor was declared as a non-performing asset by SBI on 31/7/2013. On 27/3/2015, SBI issued a loan recall notice to the corporate debtor in its capacity as the lender's agent. On 31/3/2015, some of the original lenders of the corporate debtor, namely India Infrastructure Finance Company Limited, SBI, State Bank of Hyderabad, State Bank of Bikaner and Jaipur, State Bank of Patiala and State Bank of Travancore, assigned the debts owed to them by the corporate debtor to the appellant, the Asset Reconstruction Company India Limited. On 26/2015, the appellant issued a notice under section 13(2) of the Securitization and Reconstruction of Financial Assets and Enforcement of Securities Interest Act 2002 on behalf of itself and other consortium lenders to the corporate debtor. On 1/6/2016, the appellant took actual physical possession of the project assets of the corporate debtor under the Sarfasi Act. On 26/12/2018, the appellant filed an application under Section 7 of the Insolvency and Bankruptcy Code 2016 before the National Company Law Tribunal, Calcutta for a default amounting to Rs 97 crore 80 lakh 2,973 from the corporate debtor. As the relevant form indicating the date of default did not indicate any such date, this was made up by the appellant on 8/11/2019 by filing a supplementary affidavit before the NCLT specifically mentioning the date of default and annexing copies of balance sheets of the corporate debtor, which according to the appellant acknowledged periodically the debt that was due. On 19/2/2020, the Section 7 application was admitted by the NCLT, observing that the balance sheets of the corporate debtor wherein it acknowledged its liability were signed before the expiry of 3 years from the date of default, and entries in such balance sheets being acknowledgements of the debt due for the purpose of Section 18 of the Limitation Act 1963, the Section 7 application is not barred by limitation. In an appeal filed to the National Company Law Appellate Tribunal, the corporate debtor relied upon the full bench judgment of the NCLAT in V. Padma Kumar versus Stressed Assets Stabilization Fund, Company Appeal number 57 of 2020, in which a majority of 4 members held that entries in balance sheets would not amount to acknowledgement of debt for the purpose of extending limitation under Section 18 of the Limitation Act. After a preliminary hearing, a 3-member bench passed an order on 25/9/2020 doubting the correctness of the majority judgment of the full bench and referred the matter to the acting chairman of the NCLAT to constitute a bench of coordinate strength to reconsider the judgment in V. Padma Kumar Supra. A 5-member bench of the NCLAT vide the impugned judgment dated 22/12/2020 refused to adjudicate the question referred, stating that the reference to the bench was itself incompetent. Sri Ramji Srinivasan, learned senior advocate appearing on behalf of the appellant, has assailed the impugned judgment arguing that the majority judgment of the full bench of the NCLAT in V. Padmakumar Supra was clearly per incurium, as it has not considered various binding judgments of this court, and that the said judgment was wholly incorrect in rejecting the reference out of hand at a preliminary stage. Stop.